Representing Mr. Olson.
Yes, Your Honor.
Oh, Mr. Keithley is. Is he in the meeting room?
Yes, you.
Ms. Donnelly, let's see who you're representing.
I don't represent anyone, yes. I have the 2 o'clock, but I'm here in case anyone wants to talk and get a court appointed training for probation violations.
Okay, sounds good. Okay. Mr. Rodba?
Yes, ma'am.
For the record, in the matter, the people of the state of Michigan versus Douglas Carl Roadbar, file number 19-02445FY. Mr. Roadbar, today is the date that's scheduled for an arraignment on an alleged probation violation. I have here a request and summons for probation violation. It alleges that you failed to make a payment on December 23rd, 2021, and that you failed to make a payment on January 23rd, 2022. It also alleges that you failed to pay any restitution to the victim and that you failed to appear for your moral recognition therapy at Cognitive Consultants, which was back on January 25th, 2022 and February 1st, 2022. And so because of that, probation is requesting that you be violated on your probation status. You have the right to be represented by counsel to defend this alleged violation. You have the right to have a contested hearing on the alleged violation. And if you're found to be in violation of the terms and conditions of your probation status can be extended. It can be revoked. You can be sentenced to a term of jail time, or you could be subject to additional sanctions. Do you understand that?
Yes, ma'am.
Okay. Did you want to request court-appointed counsel?
No, ma'am. I tried to contact my attorney and he's out of town, but I have all the documents and paperwork that I've been off work.
Okay, well, no, I didn't ask any explanation at this point. I just want to deal with whether or not you want an attorney to represent you. You say you tried to contact your attorney. Who is your attorney?
John Deming.
Okay. Did he represent you in this matter?
Yes, ma'am.
Okay, you tried to contact him to retain him for this case or for the violation?
Yes, to talk to him about it.
Okay. Okay, so are you saying that he's going to represent you, or is he not going to represent you on the violation?
He's not going to represent me at this time.
Okay, so again, you would still have the right to have court-appointed representation for this process. Did you want court-appointed, or did you want to represent yourself?
I'll just represent myself. Thank you.
Okay, so you have the right to plead guilty, you have the right to plead not guilty, and you have the right to stand mute. Did you want to proceed to a hearing on this matter, or did you want to plead guilty or stand mute? You can also plead not guilty. We'll set it for a hearing.
Not guilty.
Okay. Okay, we're gonna set it for a hearing, sir. It's gonna be February 22nd at 1:30, okay?
Yes, thank you, ma'am.
No problem. You'll log in the same way you did today, and then probation will be here at that date and time, okay?
All right, thank you.
Thank you. You're free to go for now. Thank you.
Thank you.
I thought I see Mr. Keithley come back. Did I make that up? He did come back. Okay. Who was he meeting with? Okay, Mr. Keithley, are you ready with Mr. Miller?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Anthony Miller. The second phone number is 20-02264 SM. Counsel appearance.
Good afternoon, Your Honor. Adria Lacey appearing on behalf of the people.
Good afternoon, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Mr. Miller, who is present via Zoom.
Thank you. Today's the date that's set for a pre-trial. This matter was reset because the application for public defender was still pending. Mr. Keithley, I assume you got the discovery and stuff that you needed at this point. Is that correct?
I'm sorry, Your Honor, I didn't understand what the court said.
I said, I assume you got the discovery that you needed at this point.
I did, Your Honor, and we are prepared to proceed in this matter.
Okay, how do you want to proceed?
Thank you, Your Honor. An offer was extended to Mr. Miller to plead guilty to an added count 2 of malicious destruction of property less than $200 in value, with a stipulated restitution amount of $514.74. In exchange, count 1, malicious destruction of property with $200 to $1,000 in value would be dismissed. At this time, Mr. Miller would like to enter a plea in this matter.
Sounds good. Mr. Miller, can you, oh, you already unmuted. Okay, Mr. Miller, you understand the offer there, sir?
Yes, ma'am.
You want to accept that offer today?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, thank you. Mr. Miller, you have the right to be represented by counsel, and you are represented by Mr. Keithley from the Office of the Public Defender. You have the right to proceed to a trial in this matter, and you have the right to have a jury trial. At the time of your trial, sir, you have the right to have the prosecution bring sufficient evidence to prove each element of the charge against you, and they have to prove each element beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
If you want to accept the offer to plead guilty to a amended or added count 2 of malicious destruction of property less than 200, you would have to give up your right to have a trial of any kind. Is that what you want to do?
Yes, ma'am.
Okay, so that means you're gonna give up your right to cross-examine or question any witness that the prosecution was going to call. You're gonna give up your right to call your own witnesses or present any evidence you believe would further or prove a defense you may have. And then you're gonna give up any right you have to remain silent and not have silence be used against you. You understand that?
Yes, ma'am.
And you wanna waive those rights here today?
Yes, ma'am.
Is anybody threatening you to get you to waive your rights to plead guilty?
No, ma'am.
Is anybody promising you anything to get you to waive your rights and plead guilty?
No, ma'am.
Okay, are you pleading guilty, sir, because you believe you are guilty?
Yes, ma'am.
Okay. Thank you. As to the added count 2 of malicious destruction of property less than 200, how do you plead?
Guilty.
Can I have a factual basis, please?
Thank you, Your Honor.
I'm sorry.
Mr. Miller, on or about May 20th of 2020, were you at an address commonly known as 5436 South Cedar in the city of Lansing, Ingham County, state of Michigan?
Yes, sir.
And is that the RPM Auto Sales?
Yes, sir.
Now, while you were there, did you punch the window of a Ford Focus?
Yes, sir.
And that ended up breaking the window, did it not?
Yes, sir.
And nobody gave you permission to punch that window, right?
No, sir.
And it wasn't an accident that you punched the window?
No, sir.
I have no further questions, Your Honor.
No question, Your Honor. It's just that it's not a Ford Focus, it's a Ford Edge. I don't think that
Oh.
makes a difference, so.
My apologies. Was that a Ford Edge, sir?
Yes, sir.
Thank you. The court is satisfied with the factual basis. I'll accept the plea and find your plea to be made freely, voluntarily, and intelligently. And I'm gonna set this matter for sentencing. How much was the restitution?
$514.74.
Okay, and Mr. Miller, prior to sentencing, you need to meet with probation so they can provide the court with a pre-sentence report and recommendation. They'll meet with you and schedule an interview to prepare that report. You need to contact them in person within the next 48 hours, okay?
You said that one more time, ma'am.
You need to report to probation within 48 hours to schedule your pre-sentence report.
Okay.
Okay, and so your sentencing date is gonna be March 29th, 2022 at 8:30 in the morning. That'll be via Zoom, okay?
Okay.
You have any questions?
Yes, can I have the phone number to the probation? Because I don't.
Yes. The number is, oh, thank you. 517-483-4424. Did you hear that, sir?
Thank you.
No problem. Do you have any other questions? Mr. Miller?
Yes, you can't
Do
hear.
you have any more Yeah, do you have any more questions?
No, I can't hear. I hear you, but I can't hear you like I was.
Okay, I don't know if you're having a connection issue. I just wanted to know if you had any additional questions.
No, ma'am.
Okay, then we'll see you on March 29th. Don't forget to go to probation within the next 2 days.
I have to go there or just call them.
No, you need to report in person within the next 2 days.
Okay.
Okay, thank you, sir. Okay, Mr. Keithy, did you represent Mr. Olson?
I do, Your Honor.
Do you need to speak to him?
No, Your Honor, that's a motion hearing today.
Okay. You have some more pre-trials on here. DeMonte Bell.
Yes, ma'am. That's me. Yes, ma'am.
Do you have an attorney?
No, ma'am.
Okay. Did you request court-appointed counsel?
Yes, ma'am.
Okay, I'm assuming you were denied. Is that correct?
Yes, ma'am.
Okay, so are you going to be hiring counsel or are you seeking to represent yourself at this time?
I can represent myself.
Okay. Well, we get an opportunity, I'll have you meet privately with the prosecutor, okay?
Okay.
Okay, there's no offer on this actually, so you're not extending an offer, you can either plead guilty to the charge, you can plead not guilty, or you can stand mute. If you plead guilty, or if you plead not guilty or you stand mute, we'll set it for a final pre-trial. You'll be ordered to appear as well as the victims, and we'll see if we can move to a trial from that point, okay? So what do you want to do today, sir?
Not guilty.
Oh. Final pre-trial, March 1st. Yeah. Do a jury trial March. Okay, sir, your final pre-trial is gonna be March 1st at 8 o'clock in the morning. That's gonna be here in person at the court, okay?
Okay.
And then I'll set it for a jury trial on March 15th at 8 o'clock in the morning, also here at the court, okay?
Yes, ma'am. So you said March 1st at 8 o'clock.
That's correct.
Come down there in person.
Come in person.
Okay.
Okay, do you have any questions today?
No, ma'am.
Okay, you're all set. We'll see you March 1st.
Okay.
Okay. Demora Jackson. Can you hear me, ma'am?
Yes,
Okay, thank you. We're on the record in the matter of the people of the state of Michigan versus Demora Jackson. The file number is 20-03037 FY. Ms. Jackson, today's the date that was set for an arraignment on alleged probation violation. I have a request and summons for probation violation here. It alleges that you failed to report monthly to probation as directed on January 13, 2022. It alleges that you failed to pay fines and costs, the amount due being $94 and total amount due being $845. It alleges that you failed to submit random PPTs and or your analysis and pay the fees as directed, and that you never returned to PATS to resume your testing. It also alleges that you failed to complete moral recognition therapy program and pay the fees as directed, that you never returned to PATS to resume the programming. And that it also alleges that you failed to provide proof of forfeited weapon to the court, and you failed to provide proof of obtaining or maintaining your employment as ordered by the court. You have the right to have a contested hearing. You have the right to be represented by counsel during that hearing. If you're found to be in violation of probation by committing any or all these actions, you can be revoked. Your probation status can be revoked. You can be sentenced to a term of jail time. Your probation can be extended, or you could face additional sanctions. Do you understand that?
Yes,
Okay. Did you want to request court appointed counsel?
yes.
I want this one in person, please. I'm gonna set your hearing for February 22nd at 1:30 in person at the court, okay?
Okay.
Okay, and if you hang tight, I can put you in a private meeting room with Miss Donnelly so that she can go over any information she needs to get from you at this time, okay, ma'am?
Okay.
Okay. Do you have any questions for the court at this time?
No.
Okay, I'll place you in a private meeting room with Miss Donnelly.
Pardon me, Your Honor.
Yes.
Can I request a breakout room with my attorney, Mr. Keithley?
Yes, Mr. Keithley, are you available?
I am, Your Honor.
I'll put him in room 3 because you're already there.
Thank you, Your Honor.
No problem. Okay, how do we? Is it Corey Paget? How do I pronounce that? Can you unmute, please?
It's Paget. I'm sorry.
You're fine, Mr. Paget. How are you today?
I'm okay. And yourself?
Oh, I'm doing pretty good. Do you have an attorney representing you?
No, I've been out of work for a couple weeks because of the big snows, and I haven't been able to produce pay stubs.
Okay. Can you do me a favor? Can you take your phone out to the front door and show me the number on the front door?
On the front door?
Yes.
Can you see it?
I can. Is that 1543?
Yes, ma'am.
Okay, and then would that be 1543 Illinois in
Yes, ma'am.
Lansing, Michigan? Okay.
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Corey Alton Paget, file number 22-00322. Counsel appearance, please.
Good afternoon, Your Honor. Andrea Lee, hearing on behalf of the people.
Okay, Mr. Paget, you were proceeding without counsel today. Today was the date that was set for your pretrial. However, we're going to address your bond right now.
Okay.
Okay. You were arraigned by Magistrate Milmore back on February 1st, 2022. Is that correct?
Yes, ma'am.
Okay, and you were told that you were not supposed to be within 1,500 feet of wherever the alleged victim lives, works, or goes to school. Is that correct?
That's correct.
The victim lives at 1543 Illinois.
No, this is my address. I'm on the lease here.
I didn't ask you
She's,
that. That's not what I asked you.
oh,
Does the
no,
victim
she does
live
not. She does not stay here. She stays with her mother.
Okay. Is her name on the lease there?
No, ma'am, it's not.
Okay. I'm gonna reset this matter for an in-person proceeding. You need to bring a copy of your lease, okay, sir?
Yes, ma'am, I will.
Okay. Actually, because I'm sure there's no offer on this, is that correct?
There is no offer, no.
Okay, so there's been no offer, sir. So we're gonna set this for a final pretrial unless you intend to plead guilty today.
No.
Okay, we'll set it for a final pretrial. That's gonna be in person here at the court. Bring a copy of your lease with you, please.
Excuse me, I'm sorry.
I would just remind you to bring a copy of your lease.
My lease, yes, ma'am.
That's correct.
And what date is this?
February 22nd at 8 o'clock in the morning.
Okay, the 22nd at 8 o'clock in the morning.
That's correct.
All right. Yes, ma'am.
I'm gonna give you your jury trial date as well. That'll be March 22nd at 8 o'clock in the morning, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Any additional matters for the record?
Nothing from the people, Your Honor.
Thank you. We'll see you next week.
Yes, ma'am. 22nd. Thank you.
Thank you.
And I can leave now?
You are free to go. Thank you.
All right. Thank you so much.
Okay. I'm not sure who's in the waiting room. We have someone else calling in from jail.
Yeah, or 2 o'clock.
Okay. Good afternoon, sir. What's your name?
Harvey Edwards.
Harvey Edwards. Are you represented by Mr. Keithley or Miss Donnelly?
What?
What's your attorney's name?
Not pretty sure. I'm not sure.
Okay, no worries. It looks like it's Miss Donnelly. When she joins us, she's in a private meeting room with someone. When she comes back, I'll see if she needs to meet with you, okay?
All right.
Ms. Donnelly, your client, Mr. Edwards, you're representing him, correct?
Yes, Your Honor.
Do you need to speak to him?
Yes, Your Honor.
Okay, I'll put you in a private meeting room.
Thank you.
Not a problem. I'll add him to your room. Yes. Ms. Williams, were you talking to us?
I
You're
was.
muted, so we can't. I was like, you're muted, we couldn't hear you.
Waiting for my turn, hon. At 1:30, I was waiting.
Yeah, you're gonna have to continue to wait until your attorneys are ready to proceed.
Okay.
Did you call me hun? Oh. Mr. Keithy, are you ready with Mr. Olson?
Your Honor, that's the motion hearing. I'm happy to go.
Right, but he's in,
We
I
can,
just want to know if I can bring him back, that's all.
yeah.
Okay, you do have two other people here. There's a Jakai Lindsay and Miss Williams. Did you need to speak with either of them?
No, Your Honor, I'm ready to go on both of those files.
Okay. Mr. Lindsay, are you there?
Yes, ma'am.
Your face. Thank you. On the record in the matter, the people of the state of Michigan versus Jakai Lindsay. File number is 20-02608. FY counsel appearance.
Good afternoon, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Mr. Lindsay.
Are you placing an appearance?
No.
This is a hearing though.
Oh, then I will. Sorry, Your Honor, I'm looking at the wrong line on the sheet. Andrea Lacey appearing on behalf of the people.
Thank you. Today was the date that was set for a hearing on a violation of probation. Are we proceeding to hearing on this?
Your Honor, at this time, I'm requesting an adjournment of this, or I guess that this violation be held in abeyance. My understanding from reviewing the request or the probation violation is that these are allegations, or at least the substance of the allegations here resulting in new criminal charges against Mr. Lindsay. Based on that, and having spoken with Mr. Lindsay and determining that those charges are still pending, I would just be asking for this matter to be held in abeyance until such a time as there's a resolution on that new case.
Does he have a court date on the other file?
I'm gonna look it up right now. I don't know.
Yes, ma'am.
What date is that, Mr. Lindsay?
February 18th. I can't remember the time, but I could go look for the paper and find the time if you needed
No,
the time.
you're fine. That's okay, sir. I just needed the date, so I know how to set this out to follow up
Okay.
on.
Okay, yes, ma'am.
What is that date for? Is it a pretrial or?
I believe it's it's my
Exam?
Yeah, I think it's the preliminary exam.
It is. It's the 18th at 1:30 in front of Judge Buchanan.
Okay, you can set it in March. We'll set it for March 8th at 1:30. Mr. Keithley, if for whatever reason he doesn't, because I don't know what's going to happen at the preliminary examination. If it doesn't go beyond them, please let us know. If it does, then we'll set it out further.
Thank you, Your Honor.
Any additional matters for the record?
Not for people.
No, Your Honor. Thank you.
You're all set for now, Mr. Lindsay.
Okay, thank you.
You're welcome. We're on the record in the matter of the people of the state of Michigan versus Tamia Williams, file number 21-01870 ST. Counsel, Ms. Williams is not here. She might be in the waiting room. Let's see if this is her. Okay, who's on the iPhone?
Tamia Williams. I was having connection issues, Your Honor. My bad.
No problem. We're on the record in the matter of the people of the state of Michigan versus Tamia Williams, file number 21-01870. Counsel appearance, please.
Good afternoon, Your Honor. Andrea Lee, appearing on behalf of the people.
Good afternoon, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Tamia Williams, who is present via Zoom.
Thank you. Today was the date that was set for a pre-trial. I'm driving my license is suspended. How do we want to proceed?
Thank you, Your Honor. At this time, the defense is requesting a 30-day adjournment for Ms. Williams to get her license. Having spoken about this with Ms. Williams and with Ms. Lacy, there's some controversy as to whether Ms. Williams is actually eligible to get her license. So I'm requesting an adjournment to give her time to actually get it and come back to court.
March 15th at 9:30. I'm positive there's probably a suspension because of this file. So if you are making advances to get your license cleared, then the only thing that needs to be taken care of is some suspensions on this. When you come back, I'll waive those, okay, Ms. Williams?
Thank you so much, Your Honor.
No problem. Any additional matters for the record?
Nothing further from the people, Your Honor.
No, Your Honor. Thank you.
You're all set for today.
Thank you.
You're welcome. Okay. I think Ms. Connolly is in the waiting room with someone. On the record in the matter of the people of the state of Michigan versus Patrick Edward Olson, file number 21-02003 SM. Counsel appearance.
Good afternoon, Your Honor. Andrea Lee, appearing on behalf of the people.
Good afternoon, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Patrick Olson, who is present via the Polygon system.
Thank you. And today was a date set for a motion to compel. Mr. Keithley, you filed a motion to compel the prosecutor to provide an unredacted copy of the police report. That's accurate.
That is accurate, Your Honor.
Okay, and I see you attached a copy of the police report, or just at least a page of the police report here. Did the prosecution receive a copy of the motion?
Your Honor, I did receive a copy of the motion.
And did you want to respond to the motion?
But Your Honor, I guess the only real response that I have is I'm unclear as to the reason that counsel needs the address information and the phone number information for the victim when it's clear that not only does he know where she lives, including showing up at a house that she's residing at now, and allegations for a PA 53 violation from November, from December. But it also appears that at one point he did live with her at that address.
Well, then,
So he should have all that information, and they were in a dating relationship, so he should already be well aware of the information that he's seeking and should be able to provide that to the
Mr.
attorney.
Keithley should be aware of this, or the defendant?
Defendant should be aware and should be able to provide it to his attorney.
Okay, well, if it's not something that you believe that needs to be kept from the defendant, I'm not sure the grounds in which you're relying on redacting it.
Well, the only person that he's mentioned in the report is the actual victim. There's also witness information that was redacted, and that is, I'm assuming he's okay with continuing to have it redacted. So if he already has information with regard to the victim, I'm not really sure what the point of the request is.
I understood the motion to want unredacted to include the witnesses, but maybe I misunderstood. Mr. Keithley, can you address that?
Your Honor, to be clear, I am wanting a fully unredacted version of the report. As to the reasons I may want it, they are not relevant. And in fact, there is no, unless there's no carve out in the court rule for assuming the prosecution agrees with defense counsel's reasons for wanting an unredacted report, that is not anywhere in either the court rule or in the ruling in Jack. Under the court rule and under the ruling in Jack, I am entitled to an unredacted version of the report. There is a mechanism for the prosecution to try to get a protective order. They have made no efforts to do so here. We would be asking that the court enter an order to compel the production of an unredacted version of this report.
Did you want to make any further response? And before you do, I do want to state here, this is not the first time Mr. Keithley has filed one of these motions. He's filed them on just about all of his cases that he received an unredacted copy. The position of your office in the past has been to provide him what he's requested.
And that's fair, Your Honor. This is the first time that I've come in contact with one of these motions. And like I said, the victim, I mean, the defendant clearly knows where the victim is staying. So the information that they're seeking is something that's already known to him and also outdated. And that's where my that's my whole objection to the motion in and of itself. Because it's already known to the defendant, and also, Your Honor, he's already sought out violations based on what he does know about this victim regardless.
Well, I don't think that there's a basis to redact a police report because he's violated his bonds. And this is information, if a protective order would be needed, your office could easily file one for justifiable reasons if it was an issue where you believe that releasing this information would create a risk to the alleged victim or witnesses. But this is information, as you are stating here on the record, that you believe the defendant already has. So I don't see why the report is redacted. I'm going to grant the motion to compel. Did you provide an order already, Mr. Kristen?
I did not, Your Honor. I'll get one over to the court. I'll try to get it in by the end of the day.
Any additional matters for the record?
Nothing for the people.
Okay,
None from defense this time. Thank you.
thank you. You're all set, Mr. Olson.
Thank you.
Are you ready with Mr. Edwards?
Your Honor, I was speaking with him when he was kicked out of the breakout for some reason. I still need to finish up my conversation with him.
Interesting. It's showing me that you're both there. So let me move you to another room and see if that helps. I'll put you in room 1. Okay. Are we ready on Mr. Harvey? I'm sorry,
Yes,
Harvey.
Your Honor.
I'm sorry. Okay. We're on the record in the matter of the people of the state of Michigan versus Harvey Edwards. File number is 22-00337. Counsel appearance.
Good afternoon, Your Honor. Andrea Lacey appearing on behalf of people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Harvey Edwards, who is appearing separately by Zoom.
Today's the date that was set for a pretrial. How are we proceeding on this?
Your Honor, at this time, there is an offer from the state prosecutor. We would be requesting this be set for a final pretrial and jury trial, but if you would want Ms. Lacey to put the offer on the record.
Can you place the offer on the record?
Your Honor, the offer is for Mr. Edwards to plead guilty to an added count 2 of disorderly drunk in violation of MCL 7501671E, which is a misdemeanor punishable by up to 90 days and or a $500 fine. He'd have to also agree to serve a term of probation and attend anger management classes. In exchange for that plea, we would dismiss the original count 1, and we would ask that he continue to have no contact with the victim, James Watkins, during the pendency of his probation.
That's the offer extended to your client, Ms. Donnelly.
Yes, Your Honor.
Your client wishes to deny that offer at this time.
At this time, Your Honor, yes.
Okay, we'll set it for final pretrial. The offer will expire at the time of the final pretrial. Pretrial March 15th. Let's see. Is he in custody on something other than this?
No, Your Honor, it is this case that he is being held on, yes.
Final pretrial next. Oh, is next week too quick to try to subpoena a witness?
Yes.
Okay. We'll do March 1st for final pretrial. 8 a.m. in person. March 15th for jury trial at 8 a.m. in person. Any additional matters for the record?
Nothing at this time, Your Honor.
Your Honor, yes, I would like to make a bond motion.
Feel free, you can make your motion.
Thank you, Your Honor. So Mr. Edwards was given a $2,500 cash or surety when he was arraigned on December 2nd. He was also ordered to be released on a GPS tether. And he is able to bond out, but if he was wanted to ask the court if it was possible to take off the GPS tether. He does report that he will be, his dad will probably bail him out and he'll be released to his father, and he'll be living with his sister.
Yeah, so here's the thing. He was arraigned actually on, you said December, but I think you meant February.
You're right,
2nd,
yes.
By Judge Buchanan. And there's a note here. He indicated that he was going to go to the victim's house in violation of the court order not to go to the victim's house. And so that's why the bond was set the way it was. And so the bond motion is denied.
If I don't do the dollar figure on the CAA form, it's because after the afternoon, it gives me a ballpark. So I have no idea.
Oh, I thought that was somebody at the jail talking. Mr. Edwards, are you trying to say something, or is that someone in your office, Ms. Donnelly?
No, it wasn't me, Your Honor.
Okay. Okay. Can you unmute at all, Mr. Edwards? I can't hear what you're saying. We can't hear you, Mr. Edwards, you're muted. Okay. I still can't hear you. You are unmuted, but I can't hear you. Can you say something? Can you hear him, Miss Donnelly? Because I can't hear him.
No, I can't hear him.
If a deputy, can you ask a deputy to come assist because we can't hear you? So I think there's something going on with your Zoom. If the deputy is there, he may need to log you out and re-log you back in because we can't hear anything you're saying.
Yeah, y'all hear me now?
There we
Okay, we can hear you now.
Okay. Yeah, I was reading on the screen. My
What
thing
were you
is,
saying?
yeah, like my thing is, I know I ain't put my hands on them. I know I didn't.
Okay.
But I can go.
Sir, Sir, this is not a time to discuss your defense to the charge.
Right.
What did you want to say other than that? Because you have the right to remain silent, so you don't want to say anything that could be used against you.
Okay, right. But y'all were just saying about me, you know what I'm saying, where I can, you know what I'm saying, move or, you know, I don't need to go to that man's house at all. Only reason why I was talking about going to that man's house because all my stuff was there. My dad picked up my stuff for me. That's all I was trying to say. I don't have no reason to go over there. I've been independent all my life.
Okay, well, what is the problem with the GPS tether then if you're not going to violate?
Because that's what I'm saying. I don't have no reason to go over there. I already got all my stuff.
I'm not gonna remove the tether requirement now. If the motion is to reduce the cash surety amount, that's one thing. The GPS is gonna remain.
Right, but I'd rather be in jail because I feel like y'all trying to say I'm a dog out here, and that's crazy.
Okay.
Yeah.
Okay, sounds good. Any additional matters for the record?
No, Your Honor.
Okay, we'll see you on March 1st, sir.
Yeah.
Well, that's all we have for today.
All right, thank you, Your Honor. Take care.
Thank you. Thank you. Have a good one.
You too.